The facts in brief are that the banks are inter-alia engaged in the business of attracting resources from customers and offering financing to others. Full stop. The banks are assessees and regularly file tax returns. Full stop. Assessment orders were passed by the concerned assessment officers, and these tax references stem from the judgments rendered by the learned tribunal. Full stop. During the course of business, the banks, inter alia, invest in securities offered by the federal government, which are issued under the Public Debt Act 1944. Full stop. The interest on such securities is paid and received according to the terms and conditions which are prescribed under the relevant rules framed in the exercise of powers conferred under section 28 of the act. Full stop. The controversy between the department and the banks is whether the interest on government securities is required to be offered for taxation on accrual or cash basis. Full stop. In some of the references, an interpretation of the income tax ordinance is involved, while in others, the relevant provisions of the ordinance are the subject of interpretation. Full stop. The second question which we are required to answer is regarding the treatment of non-performing loans or bad debts, that is, when and under what circumstances loans or debts are allowed to be treated as admissible expense. Full stop. The third question of law relates to taxation of the loan which a bank advances to its employees at concessional rates. Full stop. This statement was not contested before us on behalf of the department, and therefore, the text references to the extent of the questions relating to interest created to a suspense account are disposed of. Full stop.